everyone to our third workshop for the term. We have today the privilege of having Professor Getzler presenting his work, a few years in the making, if I may say so, because I remember discussions on these issues from a couple of years ago, and it's a great project, and yeah, the floor is yours. Josh, I will use the chat to remind everyone how to intervene if they want, and thank everyone for being here, and Josh for the presentation in advance.
Great. Well, good afternoon, everybody, and thank you for joining. This is my first ever remote Zoom webinar, so I'm a bit excited and a bit overwhelmed to see how this will work. I've given this paper in a very early form once or twice, once in Sydney and once in New York at Columbia Law School. And both discussions ended up into a kind of a free fight over whether we approved of short selling or not. I'm really not interested in that question. I'm really interested in very lawyerly questions about understanding how we legally analyze the phenomenon of securities lending. So rather than talking to the paper itself, which tends to go down a few rabbit holes along the way, I've tried to extract the main themes in about 9 or 10 slides. So I'll talk us through the points on the slides. I'm very happy, actually, if people want to raise a hand and ask a question along the way to field it, but it might be best if we can try to get through most of it, and then we'll open the floor. Great. So securities lending. What is securities lending? Straight away, we have to say that the phrase is a misnomer. It doesn't involve lending at all. Let's have a look at some judicial definitions. A very early one from 1926, US Supreme Court, up on the screen. For the incidence of ownership, the lender of securities pursuant to a securities lending agreement has substituted the personal obligation wholly contractual of the borrower to restore him on demand to the economic position in which he would have been as owner of the stock had the loan transaction not been entered into. We have a more recent Australian definition, which is quite celebrated from the Beckenwood case. The principal objects of securities-driven lending is to enable the borrower to satisfy a short sale or to complete the settlement of a sale within the time can only be achieved by transferring title to the borrowed securities to the borrower. This is the very essence of the transaction. Without the ability to pass title, there is no utility in the borrowing. Without title, the borrower cannot dispose of the shares for commercial purposes. Now, I don't know if you've ever made the joke. Someone says, "Can I borrow a cup of sugar?" And you say, "Are you going to give me the same cup of sugar back?" And the answer is obvious. No, I'm going to consume the sugar, and maybe one day I'll give you back 2 eggs, or I'll give you maybe a cup of sugar if you ask me. It's a kind of a gift exchange. The Roman law analysis of this would be comodatum, that this is a loan for consumption, but it's not a loan because title moves. A loan would tend to imply that some kind of title or right to title remains in the prior owner, and a possession is given, a temporary usage, and the title will eventually revert. Now, a securities loan is therefore not a loan because it's more like a consumption. You actually transfer to the assignee the full title and use of the security instrument, and the obligation on the assignee is to find a like security at the time of redelivery and send it back. So in other words, this is a repo, a contract for repossession, for return. And this is set out very clearly by Justice Briggs in the notable judgment of Pearson and Layman. We'll be coming back to that. So here are, now we've got that out of the way. Let's now put down the markers, what my problem is. Why am I interested in this law? It's very difficult to align securities lending with classical trust doctrine, where the assignor is a trustee who owes a duty to guard the securities or their value for an outside beneficiary. It's very hard to analyze how title can be given to an assignee. How can I be trustee for beneficiary, but give the asset away to somebody else? My hypothesis as a lawyer is if something is hard to grasp legally, then something must be wrong. Someone must be making profits by masking some form of risk or some form of arbitrage which isn't properly appreciated. And the empirical material that I'm dealing with is the litigation in London, also New York, in the wake of the collapse of Layman Brothers, this titanic insolvency. Every 10 years we say this is the greatest insolvency in human history. We had Enron was the biggest, and then we had Layman was the biggest. And we don't know with bated breath whether Layman is going to start to look like kids stuff compared to what we're now facing. And I have to say that all of his paper and all of his thinking was done before the events of the COVID crisis and the volatility we now face. And I don't know whether I'm going to have to rewrite the whole thing or rethink the whole thing in the 6 months' time when we see what we see. Let's go on. What are the origins of securities lending? Why is it done and what's the scale? And the history seems to go like this. It begins in the 1960s when custodians holding title to securities have paper documentation, title deeds, registrations flying around between companies. It's all quite primitive, and very often deals are made where the custodians cannot produce the documentation. So to avoid going into breach, I mean, we've all probably experienced that where you sell something, you just can't find it in time for delivery. You may have to get some bridging operation to find a substitute. So it seems that the very early origins involve simply filling in gaps when people can't produce a delivery on time. True securities lending, as we now understand it, probably emerges in the 1980s, and it could be the asset pricing models coming out of Chicago, development of options, instruments. Basically, opportunity makes the thief. We have the ability to start to work out future interests and start to feed short selling markets, and the lawyers begin to invent ways to move securities to people who want to use them for short periods of time. But the real spike comes in the 2000s. And my hypothesis is, if you move towards 30, 40, now possibly 50% of all securities are being held in very, very large mutual funds, institutional investment, with index investment, long hold of securities, you're taking a lot of liquidity out of the market. So the mutual funds who are sitting on these vast congeries of capital have worked out that they can send the capital out to very short-term arbitrageurs doing short selling and make money. So short securities lending can be seen as a bridge between very long passive investment and very, very short active arbitrage in securities markets. And therefore may be a good thing. It might be a good idea to move sort of a maturity shifting, time shifting operation of securities. So the scale looks something like this. In 2007, just before the first global financial crisis of the 21st century, we're now in the second. But at the first, $1 trillion in loans is estimated to be out on loan at any one time. And then after the 2008 crisis and we have recovery of the capital markets, it goes up to nearly twice as much, 1.7 trillion out at any one time on securities lending, and with 13.2 trillion sitting in inventory ready to be packaged. Now, I've recently learned something quite interesting. It's slightly more bonds being put out in securities loans than equities. And I've given you the figures here, 876 billion in bonds at any one time, 851 billion in equities. And what I didn't appreciate is we've now reached a point where about 50% of all securities sit in passive indexes. That seems to me a secular shift away from active to passive. But 30 to 40% of bonds are now passively indexed as well. So I'll be coming back to that at the end of the paper to try to work out whether the legal story can tell us anything about the deeper structure of capital intermediation when we have this huge shift into passive investment. So to reiterate, securities lending is mainly serving short selling markets. At Columbia, Merritt Fox told me that maybe 40% of securities trades are short sales. Now, I'm just reading other scholars on this. I haven't gone deeply into the structure of short selling, but it's very, very significant element in the velocity of trades in the market. And the short sellers need liquidity. They need access to readily available securities. I also see some evidence that parties who are not short selling, but trading to get control of companies may want short-term voting power. And I think there's a whole set of questions to ask about how securities lending is impacting on the exercise of voting power by beneficiaries, by intermediaries, and by the lenders of securities. But that will have to wait for another day. Who are the main players? Well, the big three, BlackRock, Fidelity, and Vanguard. What's interesting is they each have very, very different styles and practices in the way they perform it. And the brokers, the banks who break up the stock of securities and send them out to the short sellers, the experts at the Bank of America Merrill Lynch and the Bank of New York Mellon. And the significance of the trade is so great, they have their own rather powerful and elaborate industry lobby, the International Securities Lending Association, and they have a lot of very interesting literatures to learn about what they do. Okay. Here is a diagram. Can we see the whole diagram at once? Or shall I shrink it a tiny bit? Let's make it a little bit smaller. Is that all visible? Luca, can you see the whole thing?
I don't know if it ends with or like assets.
Oh, there's a list there. Okay.
Yeah.
Right. I've tried to write down a typical, okay, this is the problem. I own securities in a great big wad sitting in my proprietary fund. And if I choose to take securities out and loan them to short sellers in return for collateral and get paid for the time in which the repo transaction is being executed, that just looks like a deal that's good for both sides. The complexity comes in when the owner of the securities is a trustee. Here we are, the trustee, the mutual fund investment bank, who holds the title for a beneficial outside owner. So let's try to just go quickly through the transaction and see where the tensions lie. The trustee holds the asset and sends the asset out to the short seller on the first leg, the outward leg of the repo transaction. That's leg number one. The numbers here are the order of time in which these transactions will occur. So I've called that TL, goes out to the short seller. And the short seller will then sell the asset to a counterparty. And there could be multiple counterparties who could do a journey through various parties, but I'll just lump them together. There could be a counterparty who buys and a counterparty who sells, but let's just call that the counterparty. And when the short seller sends out the asset to the counterparty, collateral will be sent to the broker bank. And the broker bank may hold the collateral in a pool. It may provide underwriting. So I put 1A here. At the time of initiation, the broker bank may send a short-term collateral to the trustee whilst waiting for the short seller to sell, get back the consideration at 2, and then at 3, send substitute collateral to the broker bank, and the broker bank then holds that collateral for the trustee or sends the collateral to the trustee to hold. So that's how the short seller can find the money. They basically take the purchase price from the counterparty and feed it up to the collateral. So what happens next? That's part number 3. 4, the counterparty, the short sell concludes, and hopefully the short seller is very good at their job and has made some money because the price has fallen. So they get back the same asset at a lower price and they pocket a profit. They take back title, then under the repo, they return the asset to the trustee. They might go through the broker bank, but assume they go back to the trustee, and they pay a fee for the loan. And once they've finished the repo inward leg, the trustee will return the collateral or tell the broker bank to return the collateral, and the deal closes. So everybody is a winner. The short seller got their securities, they did their arbitrage and hopefully made money. The need for collateral was supplied by the broker bank with the substitute coming from the purchase price. Everything closes. So we now get to the, that's the easy stuff. Now what are the problems? One would expect that the trustee should take this collateral and hold it on trust for the beneficial owner as a substitution. But this does not in fact happen. The trustee in most cases dissolves the collateral into their own proprietary assets, does not ring fence it in the trust, but instead takes the benefit of the repo claim and pops it into the trust as an IOU note. So the trustee's taking the collateral, taking the security out, not putting the collateral in, but making a simple personal promise to the beneficial owner that once we're said and done, you will get back your security. And if you don't, because the short seller fails or goes bankrupt or can't deliver, I will then deposit the collateral to cover the position. Now that's a bit weird. If you're a trustee, it would seem to be the absolute essence of an embezzlement or a breach of trust to take an asset out and promise the beneficial owner you'll put it back later. So the answer to the puzzle seems to be you ask the beneficiary for consent. When you make your mandate for the mutual fund to intermediate and to manage the investment, you say to the beneficial owner, would you like to pay me a very low fee and we will securities lend and keep the profits and keep the collateral and leverage? Or would you like to pay a very, very high fee and we'll act like a proper trustee? My suspicion is that the beneficial owners are pretty clueless about securities lending. They may be themselves large funds, but my impression is this is quite a complex set of operations and little understood. But the beneficial owners are basically told on a take it or leave it basis, we can offer you a passive or an active index, a passive index fund or an active management mandate on extremely low fees, and we will securities lend. And because we're BlackRock, we're the largest fund manager in the world, our proprietary capital is so great that you can be absolutely certain that the IOU notes, our promises to restore the collateral, are bulletproof. You don't have to worry about the mutual fund going bankrupt. Okay, so the other issue is, what about the fees? We've talked about the collateral, but the trustee is making money from the fees which are being sent on this part up to the trustee. Who gets the fees? And there's also, while the collateral is in the hands of the trustee, it's earning interest. Who gets the income on collateral and who gets the income from the securities loan itself? And the answer to that is it's up to the parties. It's up to contract. Sometimes the short seller gets a rebate for interest on the collateral. Sometimes the interest on collateral is paid to the beneficial owner on conventional trust principles. Sometimes the trustee keeps not just the collateral for leverage, but keeps the interest on the collateral and keeps a big chunk of the fees. My own empirical research into BlackRock, which manages a certain college I belong to, which has given me access to documentation, suggests that BlackRock takes 37.5% of all securities fees. It keeps the interest on collateral. And as for the remaining 42.5%, it doesn't actually account to the beneficiary for their share of the fees. Instead, it puts it into a large pool of assets for all of its clients and says that we devote this money to tracking error correction. So when you do a passive index, you want your manager to hit the index accurately. There can be drifts, there can be mistakes, and the huge mutual fund will simply chuck money at the problem to be able to deliver to you a very, very accurate tracking of the index. And if we stand back from this and ask, well, where are the fees going? It seems to me that the trustee really has a strong discretion how much to give back to the beneficial owners. And when I became aware of this, I got quite excited and thought, let's get some litigation funding and start suing and see if we can work out, probe where all this money has gone. It's a very large part of the income of these large index funds. Let me just adjust my blinds there so I can see. Okay. And then I discovered that CalPERS and other very large pension funds in America have just begun suing precisely because of the opacity of the retention of fees on securities lending. And the whole thing is now starting to move into the courts. So let's move on. Not all of us are trust lawyers, thank God. And I thought it might be useful to have a slide up very quickly to explain why I feel tension as a trust lawyer in fitting securities lending into a classical trust model. So I've tried to write out, not using particularly technical or English lawyers' language, what does a trust look like? How ought to it behave? And above all, how does a trust give you asset partitioning? And to foreshadow the story, we could say on this model of securities lending, contract cures all. If there's enough informed consent, if the parties can work out who agreed to what, they can do whatever they like. why are we discussing, why is there a problem? And the answer is, I made the glib comment that we can't imagine that BlackRock could go bankrupt. How could all of our capital go under? But Layman tells a different story. This very proud, ancient, innovative, huge investment bank compounded all these mistakes, made huge bets on real estate markets, did go bankrupt. It was a cataclysm. Obviously, there's a political economy background about the decision of the banking system to let, and the government to let Layman go. But the point is, we have this huge event in financial history, and it's a basic insight of the law that insolvency cannot easily be privatized. When a company falls short or a debtor falls short, it's a police action by the sovereign state to work out the distribution amongst the creditors of the remains of that failed business. And when the state moves into structured insolvency, it has to give reasons. Now, I'm not an insolvency lawyer. I understand there are differences between a very discretionary approach in American law and a very legalistic ex ante approach in English law. But whichever style of insolvency you use, you're going to have to give reasons which are guiding the system about how you chop up the carcass. And what happened when Layman went bankrupt? Well, the lawyers could not work out what to do with securities lending. The contracts defeated analysis. And that, inside the priesthood of the lawyers, was itself extremely interesting to try to work out why it was so difficult. So let's begin with the classical trust. And we could say the trust gives parties two big things. Number one, inside the trustee-beneficiary relationship, the trustee owns legal title to the assets, and the A's, B's, C's correlate. When we list them under the beneficiary, we describe the rights the beneficiary has under these headings. And when we do it under the trustees list, we're doing the same thing, but looking at it from the duty obligation side. So they correlate. So the beneficiary will give their money, give their value to the trustee. And the trustee takes a title to the assets. And for those lawyers coming from civilian systems or those lawyers who didn't get to study trusts, we have to make a very important point. It's not an agency relationship. No mandate to contract is given to the trustee. Rather, the trustee is given ownership. The trustee has the normal powers of an owner, but cannot contract to bind the beneficiary. That's quite important. What the beneficiary has is an equitable claim, B, against the trustee's legal title, and also against the trustee qua owner, as owner. The beneficiary gets to control the way in which the trustee exercises their ownership. So if the trustee makes contracts that affect the legal title, they're contracting on their own behalf only. But their contracting powers and their ownership powers are subject to this equitable claim coming from the courts of equity of chancery that attaches to the person, and in older language, the conscience of the trustee, to use their legal and contractual powers, their titular powers and their powers to contract of that title, bent towards the beneficiary's benefit. Now, this way of talking about the transfer of assets for management helps explain something that has deeply puzzled English lawyers and non-English observers of the trust, which is how the trust preserves the assets if the trustee goes bankrupt. You get strong asset partitioning, where the trustee's personal debts do not go against the entrusted assets. And the reason why is, if a creditor goes against the trustee and lends money, even if the creditor does not know that the trustee is holding the assets for the beneficiary, when the creditor subrogates and steps into the shoes of the trustee, they then discover that the trustee is owning assets devoted to the beneficiary, which are not made available to the creditors. Now, continental lawyers are puzzled by this and argue you must be creating a dual patrimony. You must be taking the legal personality of the trustee and splitting it into two, and they're actually holding as two separate persons inside the same skin. So we could get into this metaphysics, but that might be for a different seminar. So that's the first thing that you get with the trust is strong asset partitioning. And Huntsman and Krachman have written at length about this, also Huntsman and Matai, about how you get asset partitioning without a franchise from the state to create a corporation. So there's a very, very interesting debate in law and economics about why do we need companies if we have trusts? But again, that's for another day. Right. What you also get is a relationship between the trustee and the beneficiary, which is highly regulated by the law to control what economists would call the principal agency problem. How do we align the trustee's powers to bend them towards the interests of the beneficiary? And we'll start with the trustee's costs. The trustee, if they have to do research and have to pay salaries, they are allowed to indemnify themselves and become a kind of partial beneficiary to take away from the trust assets. But apart from that licensed profit, they are not permitted to profit from the trust. They're not permitted to have any conflict of interest regarding the trust. They have to account for, identify the assets and return them on call. They have to manage the assets of skill and care. And none of these duties can be departed from without a strong, fully informed consent. And we see this mirrored on the beneficiary side, that the beneficiary must receive all the profits from the assets and can claim compensation in the sense of a primary obligation to make the trust whole, to make it look like it would look if all of the primary duties had been performed. And that's quite important. We don't say you get damages for harm done to the relationship. We rather say the court orders the trustee to make the trust look like it would look if there had been a full performance. And this is quite important. We call this the accounting model. Okay, what if the trustee sends out assets in breach of trust or makes stupid investments they weren't authorized to do, or simply gives the assets away? And the answer is the trustee then has a personal duty to repair the trust. And if there's any assignment made to third parties in breach of trust, equity will come along and say, we're going to clone the trust, copy it over to the mind of the third party recipient, who has an in rem constructive trust liability. And if the third party consumes or loses the assets, they have a like personal liability to reconstitute the mirrored trust. So if a trustee sends the money out to a third party who then loses the money, the beneficiary can sue both parties to restore the trust fund. There's another form of liability. If a third party assists the trustee to breach the trust, like a solicitor or an agent or a bank helps the trustee to subtract from the trust assets, then the beneficiary can go after the assistant as well as a constructive trustee to pay personally into the trust. Let's just go up to the corner here. What if the beneficiary has debts? Now that's quite an interesting problem. The beneficiary doesn't own the assets in the trust. They have a claim to make the trustee account to them for the assets. And what was decided in the early 19th century in England was that the creditors could stand in the shoes of the beneficiary and claim the value of the trust to satisfy their debts. Interestingly, the Americans have messed up that insight. And there's another whole seminar to give about how trusts have wrecked liability in America by allowing beneficiaries to insulate themselves from their normal debts. And that's another very, very stark issue in trust law. But anyway, this is the graph we need to see to understand why the mixture of trusts and securities lending becomes deeply problematic. Okay, so let's go forward. When Layman Brothers collapsed, it was trustee for vast amounts of capital for beneficiaries, which it had sent out on securities loans. And the collateral on those securities loans was in Layman as trustee when it went bankrupt. Does this mean the beneficiaries have lost their assets because they stand as a normal creditor to try to get back the value of these trades against an insolvent intermediary? So the problem was this: how do you arm a trustee with the right to do securities lending? Because we began at the start, the comodatum. The trustee, securities lender, has to be able to give the securities away absolutely to third parties. So if we refer back to my model of the trust, the one thing the trustee cannot do is send out the assets for somebody else. So you could say, well, it's fine because they swapped in collateral. It's a substitution, but they're keeping the collateral. So straight away, it doesn't look like a trustee can legitimately be given consent to do securities lending unless they put the collateral back into the trust, but which they're not doing. So there's straight away a puzzle. How can this happen? And what you could argue is, well, what the beneficiary has really done is agreed to suspend or eliminate their beneficial protections and descend to the rank of a creditor at the point of securities loan. So contract cures all. You're allowed to contract to give up on being a beneficiary and instead become a creditor. And you could argue that when the repo is concluded and the trustee puts the securities back into the trust, it's really a brand new trust. So in other words, these trust funds are flickering. They're going on and off. Every time there's a securities loan, the trust is ended, turned into a debt, and then reconstituted as a trust when the security is returned. So our problem is, what if Layman, the trustee, goes bankrupt during the contractual moment in between the two trusts? That's point B. Have we really converted the trust into a contract and lost priority? C asked the question, why is collateral not put back into the trust? And why is the interest on collateral not devoted to the trust? D says the same thing in a different way. Oh yes, when the repo comes back, you have to have a formal reconstitution of the trust. It has to be a new trust, because if I hold a trust for you and we use up all the assets and I get fresh assets, you can't have a trust without assets. So if you empty out the trust fund, there are no assets left, the trust has disappeared. So does that mean that when the substitute assets are returned on the repo, you have to see some formal declaration of a replacement trust? You can't use the old trust. That's quite a severe problem, and that was litigated. Can we save the day by saying that the IOU note from the trustee to the beneficiary, saying, I will put securities back once the repo is over, can we turn that into a kind of prophetic trust, an anticipatory trust, and say that when the security comes back, it feeds the contract and we get a specific performance order that can reconstitute the trust? Now, I've given you some language from the very able and respected Judge Lord Justice Timothy Lloyd, that rights to securities in our system usually represent a contractual or beneficial claim to an asset that sits elsewhere. Parties don't actually trade in securities. They trade in contractual and beneficial interests in securities. So if you take on that insight, it might be that the IOU note, I will reconstitute the trust fund, is itself a type of trust. And that also was litigated. So that deals with E and F. G. If we allow some kind of trust based on this IOU note being an anticipatory trust to occur, we've made the point that there are insolvency problems in the timeline of how the repos occur. But also, what happens to the managerial duties? And what about responsibility to sub-beneficiaries who may have no say in what's being done when you get a whole chain of beneficial interests? So the whole thing in layman boiled down to, what if the fund manager cannot meet its liabilities and the beneficiary is suing on the IOU note? Can it be honored? So I'd like to stand back from this problem and observe that it's not as if the kind of trading we saw in the layman's case came from nowhere. And my colleagues in the trust scholarly community have begun to identify what we call the skinny trust. And the idea is we have a classical trust, which we saw in the second slide, this very powerful institution setting up the accounting and the credit relationships and the asset partitioning. And it's often said that the trust is a kind of default law. It sets up an expectation about how parties will treat each other, but those parties are free to remold, to accommodate the deal and to change the trust to suit modern conditions. And because trusts are voluntary relationships, the courts will tend to be accommodating and permit contract to vary many of the building blocks of the trust. Now, there's an interesting body of theory taking the idea of the penalty default. This is a case where we have a default law, which most parties want most of the time, and we let contracting parties move away from the default if it suits them, but rather, as Ian Ayres explained to us at Yale Law School, sometimes the law will set up a penalty default which is so stringent, so protective, it forces the parties to recontract in almost all cases, release information about their best equilibrium point, and make the law more efficient. I find this rather appealing to explain why trusts are so rigid and so demanding, and then why we do permit contracting out constantly to adapt the trust. But the counter argument is that it should be difficult to make the contract if you're already in the trust relationship. It should be supervised by the court to make sure that what is left is still recognizably a trust. And the debate on the skinny trust has argued that the courts have gone too far. Starting in the 1980s, they've been so easy in allowing departure from the default positions of classical law. It's not clear that we really have trusts left anymore. And if that is the case, it might be that we can relax about securities lending in the trust and say there's no conflict because we actually really got rid of trusts about 15 years ago. So what I've done on slide number 6, which is now in front of you, is to give a list of the ways in which the skinny trust has emerged. So I'd like to race through them because they are interesting. One which my colleague Lionel Smith at McGill has identified is the Red Cross Trust. I actually have a Red Cross Trust myself. It's not a Red Cross Trust, but it uses this form in my own family wealth. My solicitor told me to do it. I always do what my solicitor says. But it puzzles me. What you do is you set up a trust of no beneficiaries. Instead, you tell the trustee, I will write to you a letter informally telling you the kind of people that I'd like to be my beneficiaries, and you can then bring them into the trust at your discretion, guided by what you know about my mind. So it was possible forever to have a trust listing the beneficiaries and saying to the trustee, give the money out according to discretion. The division of the wealth, you can decide according to need over time. And that is done all the time. That's easy. What is more difficult is to have a trust with no beneficiaries, but the potential to bring people into the class. And to support the trust, you put the Red Cross or some charity as the backstop. If you don't end up appointing any beneficiaries, if there are no owners, the trust can still exist because of the distant possibility that you could give the money to a charitable beneficiary. Now, just a few months ago, the Red Cross sued, claiming the money of an unappointed trust, saying, we would like to collapse the trust and take the money because you didn't bother to put anyone in the way. And they won, which has caused panic in the trust community. But Smith calls this the massive discretionary trust. So we now have a trust without beneficiaries. We also have moved to a world where the trust can be incompletely constituted, where the settlor can take it back, can make it revocable, and where the settlor can appoint people to enforce the trust according to what the settlor wants, not what the beneficiary wants, which is deeply unorthodox. Now, we had a case in the Privy Council recently, the Tasarruf case, where the holder of a power of revocation went bankrupt, and it was held that creditors could exercise the revocation power to take the trust assets to the creditors, which again caused panic. So the courts are struggling with these innovations, what impact it has on asset partitioning when you tamper with these deep building blocks of the trust, that it should be a complete gift to the beneficiaries and there must be beneficiaries. We've got rid of that now, then what happens? We've also got rid of the necessity to have assets in the trust. It's possible to have non-specific floating or future assets or shifting assets. So you declare a trust and you say, I'll put money in later, and that can work. Now, we'll come back to that later in the talk if we have time about how we can do that. Next, a trustee is supposed to hold the assets and not give them away to other people. So there was a classical rule against delegation. If I put you in charge of my wealth, you can't give it to someone else to do it for you. And parties began to contract out from non-delegation because they wanted investment management in chains of subtrust. And in 2000, the Trustee Act was passed, which said, not only do you have permission to delegate, but you have a duty to delegate if that will preserve trust value. That, again, a deep reversal of classical law. Next, we have more stringent rules to control the owner of the title, than the third parties and the contracted parties who advise how to do it. And we looked a little bit at how third-party liabilities can work. This might not be fit for purpose anymore, where the people owning the titles are completely passive nominees who do what they're told. And the people who have all the power over where the assets are sent, how they're invested, how they're protected, are contracted agents and investment advisors who have dispositive power of that title. We haven't yet really adjusted the controls of non-titular fiduciaries to catch up. I'll go faster over the rest. Inside the trust, the relationships between trustee and beneficiary, these powerful duties to constrain the trustee have been cut to ribbons in the last 15, 20 years by contract law. The court stated, this is Lord Hoffman in the Nestle case, it's almost impossible to sue for stupid investment. We do not permit hindsight to determine that some investment that goes badly wrong can be litigated. Beyond that, parties are now given power to exempt, use exclusion clauses to eliminate duties of care. Now, I think this is a bit of a horror show. I was consulting with the Law Commission, and we were trying to design a reform to constrain contracting out from duties of care. The idea that I can manage your assets, but I owe you no duty to take good care of them. And this is very, very common now in trust instruments. And this is a very large debate amongst trust lawyers where the duties of care are so intrinsic to the trust that you can't exclude them. And basically, my camp lost. That at the moment, it's settled jurisprudence. The duties of care are not part of the trust. They're really contractual, and they can be knocked out very easily by contract. Now, that means even if you have duties of care, if they're breached, they no longer are given the accounting trust protections, but rather we can do loss splitting, remoteness, contributing negligence, apportionment, laches limitations, all the ways in which courts can reduce damages as secondary obligations to repair wrongdoing can now apply. We no longer see the loss of the trust fund by stupid investment as a form of breach of the primary obligation where you have to repair the trust fund. And again, these are very large debates amongst the priesthood about how we've moved away from accounting primary remedies to secondary remedies subject to the normal common law controls. And this also feeds into remedies of account now, like rescission specific forms, have been replaced by damages. Next, and again, I find this very surprising, the skinny trust, the core duties that you cannot profit from your trust without permission, and you cannot have conflicts of interest. These can now be excluded by contract or custom. You can make your trustee into a profit taker on the trust. They can exploit opportunities. And of course, this links to a debate, I know Luca knows a lot about this, the corporate opportunities doctrine. And it's quite interesting to see how a corporate director who has a lot of dispositive power over the assets of a company can be compared to a trustee. In the 19th century, of course, directors were called trustees in the law. But with custodial trust, to say that the custodial trustee is permitted to exploit their custody to make profits and can prefer outsiders with rival clients, you can make decisions which of your clients to favor, this is a new development. So another issue was that fiduciary duty, the control of managers, was moved out of the courts into the camp of the regulators, the Financial Conduct Authority. And you get these very long statement of regulatory rules which talk about vague standards where conflicts of interest can be managed. Not that there are bright line rules that you should avoid conflicts of interest or get consent to what you're doing, but rather, maybe it's a little bit like being alert to COVID. Use your common sense. We're not going to tell you how it works. We have no will to really control you. We just will clean up the mess if people shout or if things go wrong. We're going to manage the conflict, not try to guide you how to avoid it. Recently, the Supreme Court held that these third-party assistants who were helping in the governance of the trust are not trustees for limitation and account purposes. Lord Mance gave an angry dissent. I understand he's still furious with Lord Sumption and Lord Newberg for this decision. I think that Lord Mance was correct. But again, it's a very large shift to say that these third parties in the whole structure of the trust management are no longer trustees. And finally, there was a development of law which held that the location of the assets and the giving information about the trust is no longer integral to the trust. You cannot demand your trustee explain to you what he is doing or she is doing with the assets. This is a Privy Council case from New Zealand called Schmidt and Rosewood. And again, many of us think this was a grave mistake. So what are we to do? Judges are making decisions. They have counsel of certain abilities to advise them. They're having to make a pragmatic resolution of a problem. And not every single judgment is going to please every single scholarly lawyer. And we can have disagreements about the correct policy. The problem is this: look at this long list. It all seems to go in one direction, constantly allowing the reduction, the chopping away of the classical protections of the trust, the skinny trust. So the question is this: in our second slide, we suggested the reason you get asset partitioning, the protection of the beneficiary from the trustee's insolvency, is because the internal managerial relationships are so strong, third parties should respect it. When the creditor tries to attach the trustee's assets, they discover, can't touch it because all these fiduciary duties, all these protections of the beneficiary should bind me as well. So here's the problem. Here's the long list of the way in which the internal managerial protections have been caved in. It really has turned the trust into a kind of an obligational debt relationship. Why should the third-party creditors be shut out if we have so reduced the internal controls of the trust? In other words, have we really cut through the branch we sit on? If we reduce the management, then we eliminate the asset partitioning. In other words, trust has eaten itself. It no longer really is fit for purpose. Okay, well, I told you I was going to talk about layman's. I'm allowed to speak for what, another 10 minutes or 5 minutes?
Yeah, 10 minutes.
Okay, great.
Will be fine.
Those who are curious can read the paper, but I'll take you very quickly through some of the problems with the Layman collapse. So here's the list. Layman used multiple affiliates. There were many different Laymans in different jurisdictions to heighten leverage, deepen asset partitioning, and protect the flow of profits to the core shareholders of Layman. But if things went wrong, you would be able to limit your losses. The London hub of Layman's was a center of its arbitrage and securities lending. It was probably the second most important part of the Layman's empire. And here's a part of the story which I don't yet understand. Under MiFID, the EU had imposed, in Basel, the EU had imposed regulatory capital requirements on originators to make limits on leverage. You have to have a certain amount of capital maintained in order to launch a product. And Layman's thought this was limiting its profits. It thought it could be quite difficult for it to operate on its business model, creating securities and marketing them, if it would have to find proprietary capital to back up its originations. So they had the bright idea of creating a Swiss affiliate outside the EU for origination and flipping the Swiss domiciled assets into London every single day for securities lending, and then flipping them back again in the evening. So these assets were extremely peripatetic. They were London by day and Switzerland by night. I would have thought that for fun you'd have it the other way around. And they had a computing system called the Rascal system that was shuttling the assets automatically between the hub and the affiliate. And so the idea was that the Swiss affiliate were the beneficial owners of the assets, and they would send the assets to London to be the trustee, who would then manipulate those assets during the day using securities lending as trustee, and then send it back to Switzerland, where the beneficiary would be reconstituted as owner at night, and then do it again the next day. And these involved changes to the recording of title in a computer register, where the change of a book debt was allowed to support the assignments. Now, one puzzle, Katerina Pistor identified this, in all the many huge litigations, and there were dozens of them, none of the judges said this was a fraud on the entire system of financial control. They basically said, well, parties are allowed to organize themselves to make profits, and this evasion of EU control, no one commented in any way that this was in any way wrong. I'll just leave that hanging. So this is the problem. The affiliate has made the hub trustee. By the way, all of the actors were actually all sitting in the same room in London. It was all quite fictitious, this Swiss affiliate, but that need not detain us. The hub is giving out the securities to short sellers, granting the title away. It's keeping the collateral and putting an IOU note for repo back into the trust fund. What Layman London was doing was keeping all the profits of securities lending and the interest on the collateral for itself, but it was sending the income on the securities back to the affiliate. And I've given you a note here that the various funds have extremely varied practices about how they split up the profits. BlackRock is the most greedy, Vanguard is the least greedy, and that would be a very, very interesting study to look at how the distribution of profits of securities lending works. But in this case, the two sides of the deal, the Layman Switzerland and Layman London, were really the same company, and the division between the two wasn't really that much interest to the parties. Okay, Layman is bankrupted in 2008 in September. Both sides went bankrupt simultaneously, but someone forgot to turn off the machine. And the securities lending, all the repo deals were frozen, and yet the titles kept moving back and forth for about a week until they noticed that they'd left the rascal's computer on. So there's an enormous discussion in the courts about where the title actually sat at the split moment point of insolvency. Which of the creditors, the London creditors or the Swiss creditors, who were quite distinct, should get all these hundreds of millions of pounds in money and collateral? And this was the problem that was litigated fiercely in London in front of our best judges. Okay, so here's some of the legal problems. Number one, can you have a trust of assets where the assets go out and come back again? And I argued that you'd have to have a second trust declared each time when the assets come back. And in a quite startling piece of legal creativity, an esteemed judge, Lord Briggs, building on Australian jurisprudence, held that you can be a co-owner of a trust fund with no assets in it, like a floating charge over a company, where you don't actually vest in any particular assets, but when it's time to claim, your co-ownership can descend on whatever is in the trust at that time. Now, already there's been a huge amount of discussion what the hell this could mean. And I think that the balance of argument is this might be a pragmatic way of solving the problem, but it just doesn't make sense. So that's the first problem. We have incantation by the judges saying this beneficial co-ownership of a non-corporate fund can allow you to be a trustee revesting property for a beneficiary. For most of us, it just doesn't work. So next problem. If you give consent to a party to convert entrusted assets into their own capital that they can trade upon, if you give the right to use, classical jurisprudence tells us that's not trust, that's banking. What does a bank do? It takes value from customers, it bundles it together, it sends it out for short-term or long-term loan, it does maturity transformation. And in the great case of Foley and Hill, a foundation of banking, I won't read it out, but it's a very, very important statement. It was held that the bank is not a trustee with a duty to account for the money. Rather, the money becomes the bank's, and if the bank goes bankrupt, it's only a credit relationship with its customers. And in the important Privy Council case of Space Investments, it was held, if you license your trustee to use the beneficial assets for themselves and the trustee goes bankrupt, you cannot trace the assets. You only have a debt. A very, very important principle of the law. So what happened? In the case of the repo claims, the right to get the asset back and bring it back into the trust fund, the courts held that the right to use did in fact defeat the trust. But it was held that the collateral that was sitting in the arms of the trustee when it went bankrupt could be attached and returned to the beneficiary, despite the collateral being in the full ownership of the trustee. So they took the repo right to the securities and said, that's gone, that's just credit. you lose, the beneficiaries lose. That seems to be correct. But it was held in a Supreme Court judgment, 3-2 split, that the collateral, which was intended to be returned eventually, that's a sufficient intention to impress it with a trust, even though the creditors have no inkling of it and no protection. And what was very significant was the two judges who were most steeped in the trust, Lord Hope and Lord Walker, protested vehemently and said this is totally destructive of what is left of our understanding of the trust. So if you let me have a few more minutes, I'd like to offer you some non-legal theory to try to work out how we can frame this looking for maybe a more wide lens. I'm sorry, my finger hit the wrong initial. That should be K. Pistor, Katerina Pistor, in her book, The Code of Capital, came out last year. She has a wonderful theory. This is not a quote. This is my précis of what she said. She said, capital quietly entrenches new practices. The capitalists will change the law, change the coding of the law to give them protection from risk and new access to profits. And they will settle every single problem to keep it out of court. You don't want your experimentation to be looked at, but you want to develop it and entrench it, turn it into a network of practice. And then when it gets into court, the judges don't dare knock it down. If your whole industry is built upon a certain way of doing the law, the judge is going to be quite nervous to say whole industries are illegal. So she has a nice discussion of Layman, and she makes the point again, you had to do this stuff in court. You had to articulate what had happened. And the judges are quite clearly saying, we're not comfortable with the way in which these instruments have been set up, but we have to find some pragmatic way of fitting the law around it, because otherwise we will be legally invalidating very large chunks of financial capitalism. And we all know as trust lawyers our chagrin, our upset, when really important test cases go all the way up to the top court, and a few days before judgment, the parties settle. They smell there's some risk they could lose. They don't necessarily care about the actual case, but they don't want to lose the precedent. So this is the Pistor thesis. I found it very stimulating, this idea that there's this program of shaping of the legal instruments that structure our capitalist system. And I think Layman's fits very, very well with this analysis. Now let's move on. I began talking about the weight of indexed investment, maybe 50% of capital. Is this really, all of this legal detail, all these practices of arbitrage, these are really pathologies of a system where we're supposed to have competitive arbitrage involving parties making informed judgments and predictions about where the market would turn. And one argument would go as follows. What can be a rational thing to do as an investor, as an individual, to move into a portfolio of investments with a very large sampling of the market? And then these large wadges of capital can make more money by being lent out on securities loans. And this was all invented by Langbein and Posner in the 70s and became, over 20, 30 years' time, a new orthodoxy that the trustee doesn't have to think about their investments, but can instead invest in portfolios, sampling the market, get the efficient market return, and surrender the discretion of the trustee to think about the investments. So if this has taken over a very large chunk of the market, is the securities lending feeding the short selling a kind of a blowback, a kind of a reaction that too much money is now invested blind? And here I'd like to pull out John Maynard Keynes. Are we really seeing a beauty parade gone wrong? And the beauty parade hypothesis, many of you know this well, goes something like this. Professional investment may be likened to those newspaper competitions in which the competitors have to pick out the 6 nicest faces from 100 photographs. The prize being awarded to the competitor whose choice most nearly corresponds to the average preferences of the competitors as a whole. So that each competitor has to pick not those faces which he himself finds prettiest, but those, excuse the sexist language, it's from 1936, but those which he thinks likeliest to catch the fancy of the other competitors, all of whom are looking at the problem from the point of view, the same point of view. It is not a case of choosing those which, to the best of one's judgment, are really the prettiest, nor even those which average opinion genuinely thinks the prettiest. In other words, when we make an investment, says Keynes, we only care about some guess or prediction what everybody else is going to pick. But everybody else is having the same thought. And he makes the point that this goes to the fourth, fifth, and higher degrees. In other words, arbitrage pricing is simply a huge game theoretic problem of everybody second guessing everybody else. It's not actually setting prices based on any prediction of future income or future utility. It's only a prediction what you think the psychology of the market, which includes you, will deliver. Now, when portfolio investment was moved from economics into law by Langbein and Posner, they were sensitive to the problem. And the answer was, yes, there will be this massive herding if we move the world into passive investment, but there will always be the wolves, the active investors, the arbitrageurs who on the edges of the index system will do stock picking and will disrupt the passive strategy, will set the prices. So this paragraph lodged in my mind many years ago. And when I came to the Layman Insolvency, I wondered, have they really anticipated early what would happen? In other words, has the law facilitated the rise of this unstable short-term securities lending, which is really a sign of a deeper problem, which is that capital markets have moved into the Keynesian beauty parade? I'll stop there.
Thank you, Josh. And so now the floor is open for questions. Anyone? If no one's ready, I may. Yes, Javier, please. Javier, can you speak? Oh, you. I'm promoting you to panelist. I don't know why you were not.
I'll just say, I see that my wonderful PhD student, James Cripps, is here. Hello, James. And I would like to acknowledge, and James will be certainly fulsomely acknowledged as he finishes his doctorate, that the stuff on how fiduciary law moved into regulation is James's discovery. And he knows a lot about this, and I'm looking forward to hearing what he has to say about this.
But Javier is now ready.
Right, let's go.
Yes, sorry, I think I dropped, so I had a problem reconnecting. Thanks, Josh. My name is Javier. I'm a lecturer in commercial law at the University of Glasgow, but I was a DPhil student at Oxford a few years ago doing a doctoral thesis on the right to reuse. And I have a question about your model of securities lending, because I've seen, or I assume that in the model that you have, you're assuming that securities are being lent against cash collateral, which is the cash that the short seller gets when selling the securities in the market. Is that right?
Correct.
Have you considered what happens if instead of a securities against cash transaction, you have securities against securities? So basically you have a securities swap. Could that change anything in the analysis that you have presented? I know that some of the Layman litigation, for example, and I think you mentioned this, reached the conclusion that what remains in the trust is the trustee's right against the short seller to claim equivalent securities, and that's what remains in the trust. But I wonder if, moving to a collateral swap example would change any of the conclusions.
Right. Well, in the paper, I do mention that sometimes alternative securities or treasury bonds are supplied as collateral, not cash. So I'm aware of your point, but I haven't studied it. I suspect you know more about this than I do. But I think you have to distinguish between the collateral to cover, to secure, to make sure that if the repo goes wrong, there is a recourse and you don't have to sue for it, you've already got it. And that what the collateral comprises doesn't really impact on the inward leg of the repo, which is to get the like security. So I think my understanding at present is we can divide the composition of the collateral from the quality of the repo. And if they get blended or merged, I'd need to know about it. But I suppose the point is there are going to be many different ways in which the securities lending can happen. And I was trying to isolate from reading my way through the manuals of Vanguard and Fidelity and BlackRock and the contracts I could see, and what happened in Layman's, how this could work. So I'm not quite sure how having bonds or alternative securities or cash in the collateral would make a huge difference to the analysis. But I will look out for it.
James?
Doctor, thank you for that introduction. A couple of things. I didn't really have that many particular comments, subject to a thought, because I think in London, the practice of securities lending actually had its origins, in a sense, in the practice of dealing between accounts on the London Stock Exchange, because brokers routinely, effectively short sold, knowing that they only had to complete the bargain at the next day of account, the 3-week problem or 2-week problem. And then sometime late 50s, early 60s, I think, stockbrokers began to realize that they couldn't complete if they didn't have the share certificate, because that was the way in those back old days you completed. And then what had been lost, and the practice to get a share certificate was you had to send in, sign an indemnity and have the certificate set out. And rather than go through all that hassle, stockbrokers just began routinely to borrow from the stockbroker next door and say, well, you know, we happen to have some stock certificates in these securities in the safe. Well, obviously lend it to you as long as you give them back. Obviously not giving them back, but giving more back in the future. And it then led me to think in terms of the transaction being less a lending of the security, but more a transfer of the right to demand delivery of a security. And if you have that as an analysis, you begin to think, are we talking about trustee investment powers? The investment power being the sale of one investment in order or in exchange for another. I'm not suggesting for a minute that that doesn't mean that you haven't undermined certain parts of the trust basic model, but you've got a slightly different analysis if all you're dealing with is in effect contractual rights.
The problem is equity will convert a contract for value to convey a particular asset into a ring-fenced claim. So when the asset feeds the contract, this is Holroyd and Marshall, Pallet, Shoes and Crone, the body of late 19th, early 20th century decisions, which state that it is possible to, and I gave you a quote in the paper from Justice Lloyd saying that, which is, we don't trade in the securities, we trade in the rights to the securities, or the rights to the securities, which are coming to the same thing. And you've described the origins, which I kind of penciled in the paper, but it turns into something much bigger, which is this idea that you have all the securities are held in a stable nominee account, and you have contracts or trust claims to those assets which are the subject of trade, because as incorporeals, they can simply be written down in registers. There need be no delivery. You only move back and forth. You have the contract right to ultimately take the trust. I'm moving that contract right to you. I'm giving a contract to control my contract. That enhances rapid fire liquid transacting. So what are the legal consequences? And this is a very, very big question for lawyers to try to understand the legal structuring of these trades in intermediated securities. I'll only say this, that in the early 20th century, there was a Court of Appeal case that looked at all of this stuff and said, we don't get it. I think this is very much the Pistor thesis, that we've actually created a type of transacting that the lawyers manipulate and deal, but can't explain it. They can't articulate how it works. When I'm teaching equity, I sometimes tell the story of Clever Hans, the horse that could count. And this was a horse in a fair in Germany. And the horse's owner would get everyone to watch and would ask, Hans, what is 2 plus 3? And Hans would beat his foot on the floor 5 times and then stop and be given sugar. And everyone would be amazed that the horse could count. But what the horse could do, when it got to the 5th beat of its hoof on the ground, it saw the audience get excited, and it knew if it stopped, it would get sugar. So the horse didn't actually know what it was doing, but to the outside world, the horse could count. I wonder if this is some kind of analogy for what the equity courts did when they held that the right to an asset takes the asset out of security as a prophetic conveyance supported by consideration. I haven't got the case in my head at the moment, but the Court of Appeal in the 1920s or about 1912 said, this is a horse doing arithmetic. This just doesn't work. But then the Pistor thesis kicks in. You create something that everybody relies upon, and you then have to keep going, even though you can't explain it, until things go badly wrong. So, I mean, I think this is a huge debate, which is to say you get insolvency protection if you have a contractual right to a unique asset that you paid for. You can ask why. How does that work?
I would like to make a few comments. So I loved reading the paper, especially the part on trust, which is for once, even for an outsider, total outsider like me, intelligible and fascinating. But I am more critical about the final part of the paper that you have only partly talked about during your presentation. Because first of all, I think you put out this idea that we have now some giant shadow banks out there in the big three, the three large passive investment managers. But if you look at the numbers and you do not count the assets under management, but the balance sheet of these entities, for example, BlackRock, the balance sheet of BlackRock is a fraction of Lehman's, not even close, and the leverage is minuscule compared to Lehman's. So I don't think that there is much the same kind of risk in what these institutions do, even taking into account their securities lending activities, which in the case of BlackRock are 15 billion in their last balance sheet out of a total assets of 168 billion and assets under management of a few trillions, as you say. So I'm not convinced that we are seeing a multiplied Lehman kind of risk out there. Even when you said at the beginning that 40-something% of the trades are short sales now on the market, I think that includes also positions that are closed within the day. That's my guess, because it's a very high percentage, which I don't think reflects market practice. Short selling is not so ubiquitous, but there is a lot of high frequency trading and intraday trading that takes place, borrowing from a prime broker or a broker the sums and the securities that are needed to be on the market, but that they all close at the end of the day, so there is no risk carried on anyone's books at the end of the day for that kind of trading. And finally, the point that you have also on the slide here about how this combination of passive management and securities lending might be explosive or very bad. I think that actually the opposite is true, in the sense that passive investment would be even more detrimental as a phenomenon for market efficiency if you didn't at least allow passive managers to lend securities, because that's the way it makes it much easier for short sellers to find the securities that they need to be in the game. And without short sellers, and I don't want it to make a debate about the merits of short selling, but without them, for sure, the risk of bubbles and mispricing is much higher. So you would have even less efficient capital markets, which cannot be in anyone's interest.
It's a politesse to say great questions before you answer, but these really were great questions. Did you say that BlackRock has 15 billion of its own money and 168 billion under management?
No. Its balance sheet is 168 billion in assets, and of these, 15 billions are collateral for securities lending. It's on the balance sheet, both on the asset side and on the liabilities side, but that's the size of what they are doing in terms of securities lending.
Well, here's the possible counter. When I looked at the level of securities lending in the wake of the freeze of the markets in 2008, there were spikes when 90% of BlackRock client securities of certain clients were out on loan. So it could be that obviously there's a temporal framing that has to happen, but you're saying 15 billion is not much out of 168 billion to be out on securities loans. That would still be, number one, that would still be significant if the short selling all went badly wrong. And what would BlackRock do to find, would it have sufficient collateral? I mean, also if BlackRock in its own proprietary business gets into trouble and it's holding that 15 billion in collateral, then it could lose that collateral. So, I mean, I have to go away and think about these figures, but I mean, how do we understand the solvency of a huge mutual fund if it got into huge trouble with some derivatives trades? This is outside my skill set to understand. But I would have thought people thought that Layman's insolvency was a black swan event as well. It was hard to imagine. So who knows? Okay, I can't really answer that question. I have to go and think about it. The 40% is all about high frequency trading, all closing within the day. So where are they getting the stock from for the high frequency trading? Where are the titles coming from to satisfy these trades? I don't know how we would find out.
The prime brokers that
right. Well, but the prime brokers also, and these might be the Bank of America or Merrill Lynch. They may be accessing some of his capital from securities lending. Again, I don't know this aspect, but I would like to. The question that really tickled me was your argument that if securities lending is coming into being as a reaction to the long done passive indexing, it's a good thing because it means that what Langenbein and Posner said, which is there's always going to be active people who are going to be setting prices on the edges of a very large, slow moving market. So it seems to support Langenbein and Posner. I suppose we do have to stray into the question about whether short selling is probing and discovering price information in a way which helps capitalism fulfill its mission. And I don't have to take a position on this because all I would say would be, if you made the big passive funds account properly using proper trust doctrine for the short selling operations, then the clients would discover that their capital was actually out on risk and they would be having to pay a proper fee because they're not having to secure. What BlackRock does is it keeps the fees from the securities lending and charges very little to the clients. So the clients think, I'm getting an index tracking investment with very low error from a very, very large, stable, skilled intermediary, and I have no risk. I read Langenbein and Posner, I'm getting portfolio returns. But the reality could be BlackRock is eating their lunch. They are having large profits generated from client capital, and those assets are out on risk. If the client knew that much money is being generated with your investment through active trading, why not simply hire an active trader and keep the money for yourself? So I talk to investment managers and say, do you do securities lending? And they say, no. Why would our clients want us to eat their lunch for them and expose their money to risk? Why not just hire an active investor? So the whole thing could boil down to, if people understood exactly how this all fitted together, what insolvency risks were, and how passive monies are really out on highly active short-term arbitrage, we might actually reduce the amount of passive index investment and move to some middle region where parties are paying for active investment and maybe better medium-term decisions are being made of capital. Now, this is just the beginnings of an answer, but I'm trying to suggest that it's not a healthy financial capitalism to have this beauty parade in the huge amounts of passive index investment and high-frequency trading closing every day by arbitrageurs. That if this is the two forms of decision-making with capital, then there's a huge missing middle. And if the lawyers were permitted to clarify the nature of the deals, you might get more monies being put into some intermediate zone of management. But I haven't got a better answer than that today.
Thank you for the good answer. And Javier has another question. I don't want to monopolize the debate.
Luca, I think Oren has a question. I think he's messaged me privately, but I think he has a question. So I'm happy to give him the floor because I've already asked something.
Oren, no, wait.
Sorry, I didn't notice that it was to Javier. Sorry. So Joshua, obviously I didn't understand all the legal detail of your lecture, but there was a point that you made that struck me as very, very interesting, that the economic reality of the relationship between, let's say, an Oxford College and the tracker fund is much closer to a bank than to a trust. Now, suppose that we did structure it as a banking relationship, in which case the liability of the fund to the college will have to be index debt.
Have to be which, sorry?
It will have to be debt indexed to the whatever the fund is tracking, right?
Yes.
Now, the economic implication of that would be that the tracking error would fall on the fund and not on the college, right? As long as the fund is solvent. But suppose that we do it, and it sounds to me like a very good idea because it will much better reflect the economic reality of the relationship. Still, it wouldn't stop short selling. So once it's a debt relationship, an index debt relationship, the bank can do whatever it likes in order to maximize its profits and to balance it against the probability of bankruptcy, but it won't stop short selling.
I repeat what I said at the start. I'm indifferent to short selling as a practice, and short selling might be a very wise thing to do. That's not my problem. My problem is, why are the fees not returned to the client? Why is it impossible to even find out what the profits are, what the splits are, and why is the collateral being kept back by the fund manager and not put back into the trust? In other words, why do we have this elimination of the foundations of trust protection, and yet we're still getting the courts trying to give trust protection? So your argument is, well, let's go all the way.
You can add to that the question, why is the tracking error falling on the college and not on the fund?
I would like to learn more about why you can't find in the reports from the fund managers a heading, profits from securities lending returned to the client. But instead, I'm suggesting, and I haven't tested this properly, that the profits are put into a discretionary pool and used to correct the tracking error. And I'm not sure how this can be legal. And I've asked the fund managers to explain it to me, and they can't. So it might simply be that we have to wait for CalPERS to get further into the federal court and into litigation to try to expose what's going on. But it's a bit hard to talk about the splits between profit and risk when it's so shrouded in the asset flows and the profits. And that's really my primary mission, which is to take the lawyer's tools and try to create clarity. And it seems to be opening up a trail where we're discovering that the fund managers hiding behind these obscure transactions have enormous unregulated power over the assets and their profits. So maybe if you turn the whole thing into crisp contractual debt relationships, that could help. But that would start to protect its capital, and it might make we're told we're trustees. We're told we have to preserve the wealth of the college from insolvency. So I suppose it'd be quite difficult for many pension funds, for example, have duties to maintain their capital. So I don't know where that would go. The idea everything is turned into debt. Then again, many legal systems can survive without trusts, and they might have different insolvency. So it might be a comparative issue to go and look at non-trust jurisdictions and find out how they're organized. And again, that's outside my skill set. A good question.
We only have a few minutes. I have Matthias Layman raised his hand, and then if there's time, Javier can ask his second question. Matthias, are you there?
Yes, yes. Thank you very much, Joshua, for a very stimulating and interesting presentation. Just to clarify, so in case that something goes wrong with the short seller and the short seller cannot...
I'm sorry, I can't hear you.
Oh, you can't hear me?
I can.
Oh, sorry. Why is that?
Josh, can you hear me?
Can you hear us?
Josh?
Seems to be
frozen. We're
frozen.
back now.
Okay.
Right.
So just for clarification purposes, because I'm not sure that I got that right. So in case the short seller is not able to return the security, the short seller goes bankrupt, for instance, then BlackRock will not be liable as a trustee to put in its own money into the fund to compensate for that loss.
Yes, it will.
It will.
Yeah. It took collateral, but it didn't put the collateral back into the trust fund. It just put it into its own assets.
Yeah.
And I didn't get a chance because I couldn't talk about every single point, but there's an EU directive about the right to use collateral where we have non-trust, Germany, Italy, France, non-trust jurisdictions, each with their own legal cultures and legal styles. The directive tried to say trustees are permitted or managers are permitted to use assets inside their boundaries, and you can use your own legal systems to approximate some legal articulation of how that works, but we want standard function across the system. And there's a great piece by Louise Gulliver, which explicates how difficult it was for trust lawyers to bring that EU directive on use of collateral into the language of English law. So that's a very, very interesting pocket of law. But I think the answer to your question is yes, because BlackRock or Layman's got to keep the collateral and not entrust it. If the deal fails, they have to put the collateral in. They gave an IOU note. We promised to give a substitute for the repo if you don't do it. So the big Supreme Court case I finished with the split in the court and the dissent, was where Layman, the trustee, went insolvent while sitting on the collateral when the repo deal had failed. And the question was, could the court nonetheless treat the collateral which had not been put back into the client's hands or back into the trust fund as if it had been put into the trust fund because Layman should have done it? And another element of Layman's misconduct was because it had all these affiliates, they were all basically the same company. It just did not care to do any type of strict accounting for the flows. It basically said, we'll sweep it all up later. We'll deal with the problems later. It doesn't really matter where the collateral lies. We're all the same company. So when everything went wrong and it went bankrupt, the courts then had to pick over. And they kept saying in judgments, we're kind of staggered. We can't quite believe how abandoned, how lax the accounting was between the entities.
I see the point, but still, assuming now that BlackRock is not going bankrupt, I think I would rather, as a client, be happy to have an IOU from BlackRock than actually the collateral by the short seller, because the collateral might not even reach the full value of the stock that has been taken out.
Yeah, well, the figures I see are 2% margin in America and 5% margin in Europe. But I suppose you're right. If we're going to turbulence and if bonds or alternative securities are given as collateral instead of cash, then who knows what they'll be worth at the relevant time periods. And you might prefer to have a charge against the manager instead. So what do you prefer? A sure thing against a volatile asset or a shaky obligation in liquid terms against an entity?
Yeah, that's the key question, I guess. Yeah.
But just to, as a matter of clarification, what the asset beneficiaries, so the mutual fund, are owed is the securities, not money, not the collateral. The asset manager will have to put in back the securities that it borrowed or that it lent after borrowing them from the fund, not the collateral. Just to be clear, it doesn't change the substance, but it's the mutual fund beneficiaries want the returns of the index. Therefore, they could never accept to get the collateral, which may have nothing to do with how the stock did that was lent out.
So in other words, the practice of not pushing the collateral into the trust fund is in order precisely to give it a strict denominated liquid value of what gets put back. So it's kind of a smoothing operation. Well, you could probably have the protections of the trust and still be able to get an accurate return of the value of collateral. And again, it's a leveraging issue. That would simply mean you'd have to improve the margin. Instead of 2% or 5%, you might go for 30%. And that would cut profits, and that would be safe.
So Javier had another question. I would say the final question, even though anyone is free to leave, of course, if they have other things to do.
Thanks, Luca. I was thinking about the question of why might the trustee not put the collateral back into the pool of assets. And I wonder if there's anything to do with the fact that perhaps because the trustee, I assume, has an obligation to the short seller to return the collateral once the deal is over, maybe that is another reason why the collateral assets don't go back into the trust pool. And then connected to this point, I wonder, Josh, if you've given any thought to how might the short seller react in the event of the asset manager's insolvency? Because something that, and I'm speaking from my experience working in my doctoral project, something that is quite interesting, and we have at least one example, I think, during the financial crisis, is that collateral providers were trying to pool their assets if they felt that Lehman's of the world were about to go under. So because they post 2%, 5% margin, they think, if we don't pull the collateral before Lehman goes down, we lose that over collateral that we've posted. So have you given any thought to that? Because I think that's also—
No, I haven't. That's a very, very fascinating point. So you're saying the short seller, I don't know if you can see it on your screen.
Yes.
Short seller doesn't want the collateral. Well, maybe I wonder whether the Merrill Lynch's are, as broker banks, holding the money in the collateral pool so that the trustee can see the money as in a pool that they have access to, and the short seller can see the money in a collateral pool. And that problem might be saved by the operation of the broker bank. That's my hunch. Mm-hmm. So that's one thought. The other thought, what was the first thing you said? Not about the short seller's side. But, oh yes, but with the collateral, so say to me again the first part of your question, because I had an answer, but I've lost your question.
Yeah, so the first question was, perhaps the reason why the trustee doesn't put the collateral back into the pool is because they have an obligation to return the collateral to the short seller once the deal is over.
Well, that's no problem. You can substitute back and forth as many times as you like. So when it's time to send the collateral back to the short seller, at that point, you stick the repo security back into the trust fund and swap them around. So that's no problem.
Unless you have an agreement with the short seller that they want the collateral to be segregated. Because in that case, it would be incompatible with having that in a segregated account for the client. You can't have the collateral segregated twice at the same time, right?
Well, you can have a trust of a trust, but I think the answer might be over here with the broker bank holding collateral. But then it would be an interesting question. If they're holding the collateral segregated for whom?
Yeah.
And I don't think the short seller claims insolvency protection asset partitioning as a beneficiary against the collateral. That's purely on a repo involving a contractual return. But it's a very interesting point, and I should look at it. I have to say, it's quite hard to pull the story together because each expert knows their corner. And I probably know trust law better than the short seller does. But I don't understand the short selling operations and what their risks are. And my conversations with the people in Vanguard and BlackRock, I keep hitting this problem that each person has expertise in one part of the deal, but maybe you're the guy who has to educate me how this works. But I'm finding it quite difficult to make these sorts of linkages. And maybe this is what the Law and Finance program is supposed to be about, is to give us a chance to make these connections. And I'll go back to my original hypothesis. Maybe this is where we can stop, which is, if it's hard to grasp legally, something must be wrong. And we have ample evidence in huge case after case that the judges remain puzzled. And I'll just close with one point. Kristen Van Zwieten and I invited Lord Briggs to come and lecture us last year to explain to us what happened. And we published his article, and it was quite clear that he was still trying to think through what he had done. He was himself puzzled. And I'm basically trying to pursue this legal uncertainty to the end and try to work out what its sources are. I think you've just taught me something very important, which is it could be rival claims to segregate the collateral from different corners of the transaction could be another source of the destabilization. So thank you very much for that.
Thank you, Josh, and thanks to everyone. It was a great seminar, and I hope to see you all next week for Mark Rowe, who will hold his workshop at 5 p.m. instead of usual lunchtime. So don't forget that it's later in the day.
Thank you, everybody, for joining the seminar and helping me make progress.
Thanks.